Can we determine our quorum, first of all? Member Coughlin, are you present?
I am.
Member Gonzalez?
Present.
And I am present. So we're going to call our meeting to order. Welcome, everybody. We have a lengthy agenda, so let's get started with our first item, the adoption of the agenda. Do we have any changes or revisions on our agenda this morning? Can I hear a motion to adopt our agenda?
I'll move to adopt.
Second. And all in favor?
Aye.
Okay. Aye. Our agenda is adopted. Our first action item is to renew the appointment of Amy Yeager of BioLaw Group as our interim counsel for the Labor Management Relations Board, specific to the issue that we're going to hear today regarding the request for removal of or excusal of our LMRB legal counsel. Can we have a motion to renew Amy Yeager's appointment?
I'll move to appoint Ms. Yeager.
And do we have a second?
Second.
And all in favor?
Aye.
Aye.
Aye. Okay. Can we have approval of our minutes from our last meeting? Has everybody had a moment to review our minutes?
I have.
Okay. Any changes, corrections, additions?
I move for the approval.
Second.
And all in favor?
Aye.
Okay, moving right along. Next item is to schedule hearing dates for 2 prohibited practices and 1 counterclaim. Do we have any recommendations for a hearing date?
I think we had initially proposed February 22nd, and I think collectively the board is okay with that date.
Can we check with the parties?
Yeah.
That's fine with me, too.
Okay. Can we hear from the parties? Would February 22nd work for everybody?
Madam Chairman, members of the board, good morning. James Montalano from Leeds and Valdez on behalf of the union.
I have a department meeting that day, but I don't know if my presence is necessary.
Well, and we would want to have members of bargaining for that.
That's on Friday.
Friday, February 22nd.
Correct.
The head of the negotiating team says thumbs up, so we'll be okay. And I checked with my office, and that date's good for our office as well. So I think we're okay.
Okay, thank you very much. Mr. Muir?
Thank you, Board Chair and members of the board. I think for our purposes, that date is not something that's going to be able to work for us. Michael Sivich is going to be co-counseling for the college here. We have a briefing schedule on another matter that's due at the Court of Appeals that same week. We'd ask that we have at least another week after that to prepare to make sure that we can present and exchange witness lists as required by the resolution.
Let's see if we can get an idea of the length of time, the number of witnesses that you are anticipating, and that might help us prepare.
Madam Chairman, I'm Mariko Savich, and as Mr. Muir said, I'm going to be co-counseling for these matters that are being assessed. And I apologize if we miscommunicated. I have a very large Court of Appeals brief due on March 1st. And unfortunately, I'm not making excuses. I'm just going to tell you all the truth. My paralegal's husband died. My associate is in trial this month in 2 different trials. So I would respectfully request, given what kind of time we might need and witnesses and scheduling, if we could look at the first week in March, if that would be acceptable.
I would want to consult with the board members about that. I'll share with you that given that we were scheduled to have this meeting on January 18th, which postponement is unfortunate, I'm honestly not inclined to have a very lengthy delay in scheduling members.
I have obligations, excuse me, March 8th through 22nd. Prior to that, I'm available. That would be the first week in March. But other than that, and I'm available up until from this point on through the end of February.
So that would be the 8th is Friday. You're not available on that date.
No.
So and March 1 is your deadline.
Yes, sir.
Could the parties talk to us about how long you think this hearing will last, just in terms of number of witnesses and presentation?
I think maybe 2 witnesses on our side to talk about the negotiations. Half a day for our side.
I think we would be looking at 2 to 3 witnesses potentially too, for the same reasons. So half a day for the presentation parts, but I expect that we may need more than 1 day, just to be sure, so there's time for the board to get all the evidence and hear. But I think it's get it into 1 day.
I'm going to suggest that we communicate by email. Calendaring is always rather time consuming, so maybe we can present some dates to the parties for your consideration by email, if that would be agreeable.
Yes.
And I don't want to commit to waiting until the first week of March, but we will look at the time. Let's look at all the dates that we have available between now and March 7th. And of course, council needs to be available as well on those dates.
Madam Chair, under your rules, you're required to set the hearing within 45 days of the date of
That's
filing. So
right. And
I'd
that was yesterday, wasn't it?
Well, yesterday was the date when you were required to actually make a setting for later.
Mm-hmm.
The actual hearings are supposed to happen within 45 days, and these are work
Thank you.
days from the date complaints were filed. So at this stage, if extensions are being requested, I would request that the
We
board
would need that in
ask the
writing.
parties to extend those deadlines until an acceptable date can be achieved, just to make sure that there isn't a question about compliance with your rules.
Thank you. Mr. Kennedy, would we need that request for extension in writing?
No, I think if it's on the record here today verbally, I think the parties can certainly provide that to you as part of your record, part of the minutes.
And I'd want, please.
Thank you, Madam Chair. For San Jose Community College, as we've done with yesterday's date, we agree to waive those deadlines to ensure that we get a schedule order that works for all parties.
Madam Chairman, we obviously are concerned that we filed this more than 2 months ago, or about 2 months ago. And we understand the scheduling concerns of all involved, but we would like to have this done as soon as possible. We would not oppose an extension into the first week of March if that's necessary.
And Madam Chairman, I will represent that I am available any day the first week of March, the 4th through the 6th or 7th. I appreciate the consideration of council and the board.
And we do have I do have a concern about March 5th as a date. That's a bad date for us. Perhaps the 6th and 7th could be a date that might work.
Do we want to take out our calendars now and nail a date while we're all here? Shall we do that, or shall we go have email communication and figure it out?
Trish, are there dates that week that are problematic in terms of space here at the school?
That was the second or the 8th, I think we just shut out, which wasn't going to work anyway.
The earlier the better for me. in the week, because if it's going to take 2 days, we would need to start at least by the 5th or 6th.
There's really not much of an option. It's the 4th, 5th. But it's actually, the union has a problem with the 5th. So it's really 6th, 7th, or 4th.
4th, 6th.
With a break in between, which is fine.
Mhm.
So 6th, 7th.
I have a conflict on the 4th. I could probably change that.
That's an all campus.
Right, and that date isn't good for
Yeah.
Tom. 4th and 6th.
Or 6th and 7th.
4th and 6th.
What, 3? No, 6th and 7th.
6th and 7th, or rather than 4th and 6th.
Just do that to avoid the break in between.
Okay.
What's that?
6 and 7. 6 and 7.
7th is not good for me, I'm sorry.
Okay. So 4th and 6th.
4th and 5th, that's fine with me.
4th and 6th.
Oh, 4th and 6th.
If necessary.
Okay.
The second day is necessary. Okay, March 4th, and if necessary, March 6th. Is that agreeable?
Did you say birthday?
No, not the 5th, March 4th, and if a second day is necessary, March 6th. Is that agreeable to everyone?
Yes, that's right.
Okay. Good. Saves an email flurry. So we are scheduled, under item 3C, we have scheduled our hearings on 2 prohibited practice complaints and 1 counterclaim for March 4th, and if we need a second day, March 6th. Okay. Okay, we are ready to move on to item 4. Please.
Quickly on the scheduling, there are requirements under rules for exchange of witness lists, et cetera.
Yes,
That email will, I'm assuming, will come out full schedule for the council.
yes.
Thank you.
Thank you for clarifying that. Okay, are we ready to move on? Okay, the agenda item that we have all been anticipating, item 4, our hearing. And I'm going to look to Ms. Yeager for guidance on how to proceed to make sure that we're structuring our hearing in the proper way.
And Madam Chair, I'm going to step away from the table.
Thank you.
It was-
So, Madam Chair, have you given any kind of a scheduling order or timelines to the parties in preparation for today's hearing?
We have not.
So, I would recommend that we set up a time schedule for them for this morning.
Okay,
Up to 30 minutes for each side to present their case.
okay,
Up to 30 minutes, not
Okay.
more than that, we can time it. And then after that, they can each respond. And if they have questions for Mr. Kennedy, do you want them to have the opportunity to ask you questions if there's
That's at the pleasure of the board. I'm not a party, so
right? Yeah.
it's up to the pleasure of the board to handle this as they choose. I'm here.
I think that I would like the board to have an opportunity to ask any questions, certainly of the parties as well as Mr. Kennedy, if we feel the need to do so.
And we can do that after each party presents their main case. I think there should be no limit on the questions from the board.
Okay,
But for the rebuttal, I think we could limit the rebuttal to 5 minutes.
is that an agreeable schedule?
I have to ask, are these microphones or not? Is anything mic'd? It's mic'd, but can people hear me? Maybe I was anticipating being by a microphone. Could people hear what I just said?
Yes.
Yeah, okay.
Okay, I'm going to remind everybody that our hearing this morning is limited to a single issue, and that is the issue of the union's request for removal or excusal of Mr. Kennedy as our legal counsel for the purpose of these prohibited practice complaints. And I'm going to ask everybody to please limit your arguments to that issue and let's not get in today to the substance of the PPCs. It's not relevant to our issue today. Okay, so the first to present their argument would be?
The party's bringing the complaint, so Mr. Montalban.
Okay.
Would you like counsel at the table?
Yes.
Please.
Madam Chairman, members of the board, thanks for listening to us and our concerns today. This issue came up last year and was presented to the board and the way that you board members since then. This issue has been briefed. And so I don't need nearly a half hour. I don't need very much time to present the case. I won't belabor my brief. I won't go over it in detail. I assume I'll expect there may be some questions, but I will just highlight a few things in the brief. One is basically what we're arguing here is a due process concern. We are concerned that we get a fair adjudication before this board. We have expressed our respect for Mr. Kennedy and his professionalism, and this is not a personal attack on any one individual or on the board or on the college. What we are seeking here is the assurance that we get a fair adjudication before the board. And our concern is essentially what the Court of Appeals and with the support of the Supreme Court in New Mexico has said is not only are you entitled to a fair adjudication and an impartial panel to present your case, but you also have to, a board at the administrative level as well as at the upper levels, have to give the appearance of fairness. And that is where our concern comes in. We're not suggesting that anybody here is not fair. We're not suggesting that anybody here has an actual bias against us. What we are suggesting is that the situation creates the appearance of potential bias. And the courts have been absolutely clear on this, that it's not just an actual bias, but it's the appearance of bias. What the college is suggesting is that we cannot raise this issue because we haven't been harmed in any way. But we don't. In such a situation, it's the appearance and the potential for harm that is the concern. We don't see why we would need to go through and adjudicate one or several PPCs and then have to go to an appeals court to raise the issue of harm. We believe that the harm is apparent and the potential for harm is apparent. The case law we state is rather foundational, that supports not only the 14th Amendment of the U.S. Constitution, but also the New Mexico Constitution as well, which protects the due process rights of people seeking to vindicate their rights before an administrative board. I won't go through those. We highlighted a lot of the issues that were raised in there. The case of Los Chavez, which we cite on page 4 of our brief, states that the decision-making body, in that case, it was a zoning board. So we are talking about administrative bodies. When board members act in a quasi-judicial capacity, they must act like a judicial body bound by ethical standards comparable to those that govern a court in performing the same function. And it says, the Constitution and the mandate of the foundational case of Reed tell us that the presumption of bias is fatal to the due process rights of parties appearing before quasi-judicial administrative tribunals, which this is. We believe that should be extended not just to the members of the board, but but anybody who may potentially be in the room when that decision is being made, and offering legal guidance to the board in a closed session when they are deciding and debating the merits of a PPC. The AFSCME v. Martinez case that we said on page 5 talks about predispositions, the appearance of fairness, a possible temptation to the average person sitting as a judge. And we argue that by extension, that would include all the legal guidance that you get in that room if you are deliberating on the merits of a PPC. We again don't suggest that there has been actual bias shown. We've been treated fairly during the procedural process. We don't challenge the use of a college-appointed a college-appointed attorney to advise this board when it comes to procedural matters and the scheduling of PPCs and judging the facial validity of a PPC based on whether the ordinance has been followed when it comes to filing a PPC and including the elements necessary in the PPC. Our concern is that the college has appointed someone who actually has been involved in recent litigation against our sister organization, the AFT, and we just believe that for our purposes, the PPCs that we bring, we would ask that Mr. Kennedy be recused from those deliberations and that other counsel be used if necessary when it comes to deliberating the merits of PPCs. And if there are any questions, I'll answer questions, but that's the substance of our motion. It's a due process concern that the appearance of fairness be present at all times.
Thank you, Mr. Montalban. We have questions at this point? Mr. Gonzalez?
I do have questions, but I think I'd like to hear from the other parties first.
I think I would like to proceed the same way.
Thank you, Madam Chair.
Reach for my water.
Members of the board, I appreciate Mr. Montalbano's approach. I think, as he stated, we briefed this. You've been able to read our papers, so I'll do the same. I don't anticipate taking 30 minutes, but I appreciate the time. We've heard a lot from Mr. Montalbano about appearance, but there are laws that govern the relationship here. There's laws that govern how this board is created. There's a statute that addresses how the local board is created and the powers and duties. That statute is the PIVA at 10/70/11. And at that, you'll notice in our brief, we discussed this for your purposes. We address this in the first 2 pages, but just for your reference, that statute states specifically at section B that the board, the governing board, in this case, the college board, has the authority and right to hire personnel or contract with third parties as the governing board deems necessary to assist this local board in carrying out its functions. The idea behind that is to allow the college the opportunity, since they are appointing this individual to support the board, they have the authority under that statute to determine who that person is and what they do to support this board. In doing so, the college sought an attorney with the experience at the level of public school education, higher education, and specifically with knowledge and understanding of the labor law as it is in New Mexico. Mr. Kennedy, as the union's brief points out, has experience in all of those areas. Mr. Kennedy is not a decider of fact. Mr. Kennedy is somebody who advises the board specifically, as Mr. Montalbano stated, on the procedural aspects of the law, but also on the law as it is in New Mexico. His authority does not extend to this board's decision making. He has no right of vote on this board. The way that this is set up under 107011 for the governing board to hire folks to assist this board, and the authority given by that statute is also replicated in the resolution at Section 8. But again, it's not unlike an insurance company who hires counsel to assist. They pick the counsel. The insurance company ensures that the attorney is competent to advise their client on the aspects of the law that are appropriate, and that's what we have here. We hear that there's a due process claim. Again, Mr. Kennedy has no voting rights. He's not a member of this board. He cannot affect this board in any other way than to advise you on the law. The substantive law that is, as noted in our brief, is there's a problem procedurally for the AAUP to bring this. They don't have standing. Case law in New Mexico and under the United States Supreme Court required that a litigant demonstrate injury in fact, causation, and redressability to invoke the court's authority after the merits of a case. That those protections are put in place, those standing protections, specifically to protect due process. That's how the courts came to those issues. So the idea is that if Mr. Kennedy cannot directly affect the board's decision, he's not a voting member. There is no due process problem. There has been no injury in fact. There is no causation. The idea that Mr. Kennedy can be removed by this board is the board's authority potentially. But again, the AUP can't even bring that claim because, again, there hasn't been any injury. There is no causation. And again, factually, Mr. Kennedy cannot affect this board's decision by a vote. I think the other issue that we briefed here is that Mr. Kennedy has a duty under the rules of professional conduct to the client, who is this board, to not be biased. And the issue of the fact that he's been involved in litigation with the quote sister organization it should have no effect here. Mr. Kennedy is obligated by the rules of professional conduct to advise this board in the capacity that he's been hired, and that is only to provide the board with procedural information as it relates to the statutes that govern this board and the creation of this board. And he's done so as far as we've come. There's been no injury in fact as stated by the union, by union's counsel. There's been no actual bias that's been present. And so there's no effect that removal of Mr. Kennedy will have on these proceedings.
Thank you, Mr. Mayor. Is there anything additional?
No, Madam Chair, thank you.
Questions, colleagues?
You go.
So, I want to clarify, Mr. Montalbano, that you stated that you're not suggesting that any actual bias has been shown by Mr. Kennedy. Is that correct?
That's correct.
Okay. So
We're also arguing that the actual bias need not be present for us to make this.
I understand that. So there's no advice, action that Mr. Kennedy has demonstrated. We understand your assertion that actual bias does not need to be demonstrated. But for our information, you are not suggesting that there has been any action, any advice that has biased this board against the union.
Madam Chair, members of the board, what we're aware of is we have dealt, as always, professionally with Mr. Kennedy when it comes to procedural matters before this board. We're not privy to anything else that involves the board and Mr. Kennedy, in particular closed sessions. We obviously don't know what goes on.
And you're also suggesting or stating that the college has appointed someone who has been engaged in deliberations against a sister organization. Is it your belief, your understanding that Mr. Kennedy has been involved professionally in any action against a sister organization?
No, his law firm has represented, has been the law firm on the other side of the case involving our sister organization. He or his law firm, no, have not taken personal direct action against a sister organization.
Okay.
If I understood your question.
So you're stating that his law firm has been involved in this litigation, not necessarily action, but this litigation against a sister organization, but you're not suggesting that Mr. Kennedy has been involved in that case.
I'm not aware if his level of involvement in that case.
Do you think that he has been?
I'm not.
Is that your concern or part of your concern?
That's our concern that he may have been.
Okay. Other questions?
Is the crux of the union's complaint here the way in which Mr. Kennedy was chosen to serve as counsel to the board?
One of the concerns is that he was chosen and imposed onto the board by the governing board.
If Mr. Kennedy was chosen by the board, would the union have the same objection?
We would have the same objection, but we would have a certain level of concern about that choice. But if this was a truly independent move by the labor board, this board, that would lessen our concerns. But I would think that we would. I think we would still have some concerns about the choice, given that. I don't know, if it was truly independent, then that would reduce our concerns.
So help me understand, what do you mean by truly independent versus what? I mean, what I'm suggesting is if the board, under the statutes that are being cited to us, decide to hire Mr. Kennedy as counsel to the board, would the union raise an objection? I'm assuming that well, I guess I'll put the question to you then. What objection would you have?
Our objection would be, our concern would be about having him as part of the communicative process in a closed session, considering the, again, potential appearance of bias, considering that his law firm, which boasts of its management representation against unions, and in particular a case that involved our sister organization of teachers. I will note, Madam Chairman and Mr. Kaufman, that the membership of this board, like other labor boards, local labor boards, can change over time. And our experience has been that there's not always going to be lawyers on the board. In fact, it's very common not to have lawyers on the board. And there is a concern that boards tend to rely on their legal counsel, especially when it comes to deciding the merits, applying the facts of a case to the law, and getting that advice. We would have concerns about what happens in that closed session when the actual decision is being made.
More questions?
Yeah, a couple more. So, Mr. Meir, the statute that you're citing gives this board the authority to hire a lawyer, correct?
The statute I'm citing gives the governing board the authority to hire a lawyer. It states specifically at 1070 that the authority to hire personnel or contract with third parties is the appropriate governing body. Here, that's the governing board by statute. If you look at 1070-7, that the appropriate governing body for the college is the governing board, and that follows by that governing board deems necessary to assist the local board in carrying out its functions. Here, the board sought counsel that had the experience, again, to advise the board properly on these actions. Mr. Kennedy himself has experience in the public school arena and at higher ed in labor relations, and that's the purpose for why he was hired. There was no other purpose than to find somebody that had that experience that could properly advise them.
How do you square that statute with the statute that gives the board the authority to, this board, the authority to hire and fire counsel?
I think it's squared by, if this board brought this, I mean, it gets to our standing argument, right? The union doesn't even have standing to bring this on. If the board was dissatisfied with Mr. Kennedy's service, we are not arguing that you would not have the right to replace Mr. Kennedy. We have not seen any or heard from the board that they were dissatisfied with Mr. Kennedy. We're presenting essentially the fact that the hiring was not improper. It was the appropriate thing for the governing board to do, to find an attorney that had the proper experience to advise the board. If the board was dissatisfied with the service, we obviously would have no argument with the board's decision to hire a different attorney. Again, subject to availability of funds by the college, right? That's the other caveat there. But the idea that the union can bring this claim without any injury, with concerns about a lawyer's having been involved in some litigation at some point, it's a slippery slope. I mean, the union can then argue at any counsel you bring, they can argue and come before you and try to get them removed. I mean, it's not, an attorney, again, has that obligation to not bias, to not advise a client with any bias based on previous actions or in previous cases. I'd note, if I could, I think that it's important to note that the case law that the union cites in their brief, none of that case law, when read in its entirety, extends those concerns of bias to any third parties. They're directly square on the members of the board and the folks that are decision makers in those. In fact, I have a copy of the Martinez case for the board members, a copy for each of the board members. I'm sure Mr. Montalbano has one, but I have one for him as well. And in that case, I just bring the board's attention, on page 4 of that opinion, I'll read those for you, that the question in that case, and states specifically, unequivocally, that the question in the case is whether the governor's removal of the members of the PELRB is at odds with the governor's responsibility to act, intended goals, and effectuate. So in that case, that decision by the court was squarely on the facts of that case. In that case, the governor attempted to remove and appoint members to the board without going through the appropriate processes, right? So we're talking about members of the board and their ability to decide. We're not talking about that here. This does not extend to third parties. It doesn't extend to a lawyer who's complying with the rules of professional conduct and advising the board in the appropriate capacity.
Just to follow up, what do you think about the argument that, I understand your standing argument, but don't all of us have an obligation to avoid the appearance of impropriety? What is your response to the statement that Mr. Kennedy's presence as counsel to the board creates the appearance of impropriety?
The appearance of impropriety extends, our concern with that is the appearance is related to his law firm representing some client in some defensive litigation brought by a sister organization, the AUP. Sister organization where that's even established. Again, there's nothing that somebody from the public could look and say, oh, Mr. Kennedy is going to affect us somehow. He doesn't have the right to vote. The appearance of impropriety does not exist. If you can find an attorney that only does one thing or only advises the boarders on record as saying, I'm going to get the AUP, and then they're serving, I think then you have something that extends the appearance of impropriety. I don't think it exists here because Mr. Kennedy is acting independently to represent the board.
I have a couple of questions. Would you provide some evidence on appearance of fairness for me, please?
Evidence?
Yes, of appearance of fairness in the context of this hearing.
In this case in
Yeah.
particular,
Yeah.
I think the things I've stated already are first of all, back last year, Mr. Kennedy was appointed by the governing board, and that was promptly followed by a PPC brought against the union by the by the college. At that time, your predecessor was on the board, and we had concerns about the appearance of bias there, and that was more directly on point with the case, with the Martinez case and the other cases of, in particular, a board member. We are extending our argument to that extent, and we do have concerns about Mr. Kennedy's firm being involved in litigation against our sister teachers movement.
Examples? Give it examples. Any examples from your experience on any litigation or his firm's work with other organizations like the AFT? I mean, can you cite what actually has happened?
I'm sorry. We quote from his law firm's website about their defense of management in cases against unions. So that's the evidence we've cited and that I would point to today.
I understand you did bring this before with my predecessor, and I did read those minutes. I would raise the question, why didn't you bring this before the governing board and not this board, this issue? They were the appointing authority. They made the appointments, and as counsel indicated, my experience, etc. Question.
We certainly could take this case to a district court for a declaratory action and challenge some actions of the governing board.
Mm-hmm.
We considered this a matter that's before the board, and we want to bring PPCs to the board, and we believe this board should address it. We believe that this board, I mean, it's the simplest way to do that. Go into district court and bring declaratory actions. It takes a lot of resources, and the three of you are the decision makers here today and in the future, and so we just ask, as part of our relief, that this issue be addressed and be considered. So that was our strategy there. Not to say that we couldn't approach it.
Okay.
What would you do if this board reaches a decision that you're not happy with? Is that something that you're holding out as a possibility? Going to district court and requesting a declaratory action to challenge the decision by this board?
I think if we did it before, if it were confined, Madam Chairman, if it were confined to this board and this board's decision,
Mm-hmm.
I think it would be just one part of the mix of a potential appeal to district court
Mm-hmm.
of the decision. It would be part of a basis for appeal if any exists.
Mr. Meir, is it accurate that there is a provision in Mr. Kennedy's contract that would permit the removal of Mr. Kennedy if that were requested by this board? I'm
not privy to the contract that he has with the college, but I assume that there would be something in the contract that would allow the governing board or the board to. I can't speak to it directly.
Okay, because you referenced that, and I don't remember, I didn't write down your language, but if this board were to make the request to remove or replace Mr. Kennedy, that is something that the governing council would act on.
The governing, I assume they would. Yes, ma'am. But what I actually said was, I think the concern that we have is as Mr. Montalbano raised this before, the only time this challenge came was once a PPC was filed based on the actions of some of the union members. That was when this action was filed. It was then agreed to be removed as a concern after that PPC was dealt with by the parties and was settled. It comes again now that there's other issues that are before the board, and I don't want to address those because I've specifically been asked not to. But I raise that issue only to say that if the board had a concern with council, it is my understanding that at this point he would no longer be serving. There would have been some kind of action this board would have taken to do that. Now, again, I apologize. I don't know the ins and outs of his contract with the college, but I'm assuming that this board, based on the structure, if they had a concern, yes, that would be something the governing board would absolutely listen to.
Thank you. Mr. Montalbano, what is the, who do you see as Mr. Kennedy's client?
I would see Mr. Kennedy's client as this board.
Is it accurate, as Mr. Muir asserts in his report, that an attorney, I'm not an attorney, okay? So is it accurate that an attorney is ethically bound to serve the best interest of his client?
Yes.
And sometimes, is it true that the client may be somebody different from the person who writes the check or who requests the service?
I don't know. I think these boards are unique situations, so I don't know if I would go that far as to say, yeah, that's cool. But I think the way these local boards are set up, there's tensions in PIBA, in the state ordinance. There's tensions in the local ordinance and their own regulations as to it's a very there's overlapping interests here, and so we have a concern in general about how it's set up to begin with. But here in particular, we just raise these concerns in particular.
The cases that you cite, and I don't see any exceptions, seem to refer to the potential or the appearance of bias in the deciding party or parties, in the hearing board, in the judge, the justice, or the magistrate. In your opinion, does whoever the counsel is for this board serve any of those functions?
Again, Madam Chair, as I indicated earlier, yes, the cases cited go to board members of these adjudicated bodies. Our concern here is that these boards are unique in that they get legal guidance. We're not in the room when the adjudicated process and the deliberative process happens, so we don't know what happens. But to the extent that that process would involve non-lawyers seeking advice from a lawyer in order to decide a case, we think that crosses a line into, if not being a deciding member, having undue influence over deciding members. And so thus, that influence, it would raise concerns that would touch on all the cases we cite that talk about board members.
So your argument on the basis that the appearance of, in this case, could create bias, is that what you're saying?
I'm sorry,
You're saying the appearance of the counsel and any advice to this board could create bias, but what I'm hearing you saying, it does create bias.
I'm saying it does create the appearance of bias. The potential, the appearance of the potential for bias. Again, no actual bias is not required, just the appearance or the potential for it.
Does that, I apologize for sort of harping on the issue, but does that go back to the fact that Mr. Kennedy was chosen by the governing board, or his background, or both?
I would say both. I mean, we definitely had an initial concern when the governing board appointed a member and then contracted with a lawyer and then brought a PPC against the union. That's when our concerns initially were raised, and they haven't been mollified since.
What do you think about Mr. Muir's argument that the governing board is statutorily given the authority to hire counsel at the outset?
I can't argue with PIBA.
So you agree with it, that at least in the initial formation of the board, the governing board had the authority to initially hire counsel. It's the choice of counsel that was the problem.
To the extent that PIBA allows that, yes.
Any other questions for council?
No, not right now.
I'm sorry.
I just wanted to address one last issue, and I don't know if we're in the rebuttal phase, but I think since this didn't come up, and Mr. Montalbano raised a point, this is based on your question, Madam Chair, that does the case law support what Mr. Montalbano's point is about the appearance? But I think the college's concern with that, and our position on it, is what the union is essentially asking this board to do is extend the law that the courts in New Mexico have refused to extend to third parties, right? So they're asking, hey, the courts haven't gone this far, but board, we're asking you to do this independently. And I think that given the structure and the statutory allowances here, that request, I think it just can't be squared with the case law. So I just wanted to raise that point, that if that's an issue they're asking this board to address, it hasn't been addressed by the courts or has not been extended that far.
If I may?
Please.
I don't know if it's accurate to say that the courts have refused to extend it. And I don't know if it's a matter of extension. It's just that it hasn't been directly addressed by the courts in their case law. But what we're saying is, as we read the case law, we can see how it can include this situation. It's not like somebody has brought this before any court and the court has said no. It's only board members.
Understood. Do you have any closing comments?
No.
Thank you.
Questions? Okay, would either of you object to the board asking some questions of Mr. Kennedy?
I don't think I'd object. I just don't know if there's, this was an evidentiary hearing. I don't know if the board asks questions, if then Mr. Montalbano and I can ask questions. I'm not sure how that would square.
I would agree, and then I would add that we didn't bring this case to put Mr. Kennedy on the spot, or to make this about him. But I wouldn't object to whatever the board would like to do, to the extent that it wants the full picture here to make an informed decision. We didn't bring this personally against Mr. Kennedy or to put him in the hot seat. That's the only point I would make.
There may be some issues that he may be able to clarify, and that might be to everybody's advantage, but I'll leave that to my colleagues.
Madam Chair, I didn't mean to say that we object to that. I think the
understand.
issue is if the questions raise issues that Mr. Montalbano and I address, whether we are allowed to do that, given that this was illegal or that's.
I understand.
Thank you.
Chairwoman,
Please.
Excuse me.
because this is really seeking evidence on this question, if the board had a question that they did want to ask Mr. Kennedy that was evidentiary in nature around some of the factual things that both counsel have brought up in their briefs, I think the limited purpose of a question to Mr. Kennedy, if the board wants to ask, would be appropriate. But I agree with counsel that it's an evidentiary hearing, so it would really be limited to either the claims or information that counsel have brought up either in their brief or in their presentation.
I
So I
understand.
think it would be, for the board, not for counsel to ask questions.
Right.
I do think, at least I have some questions for Mr. Kennedy that are evidentiary, because I think there have been facts raised in the briefing that I think need clarification, and we can only get them from Mr. Kennedy. So I think it shouldn't take very long, but I think we can probably confine our questions to evidence that we need to see worked out.
I would agree. My question would be, would that be an open hearing, or should we do that in closed session?
That would be now,
Mr.
correct?
Kennedy.
Yeah, I think it's
It would be now, as part of the hearing, so it would be information provided as evidence that would be on the record.
Okay. Thank you all very much. And Mr. Kennedy, could you please join us?
Good morning.
Good morning. Thank you. Colleagues, your questions for Mr. Kennedy?
Go ahead.
I think that, could you clarify for us, there have been some comments made in the pleadings and then today during the hearing regarding your firm's role in various matters. My understanding is that the contract with the college is with your LLC, and I want you to clarify what the relationship is between the Cuddy and McCarthy firm and your firm, and just sort of flesh that out for us because I think that's unclear in the pleadings.
Okay. Thank you very much. I also share your counsel and the other counsel's concerns that this isn't an evidentiary hearing. So I think it's probably appropriate that we be as circumspect as possible not to turn it into one. But the fact is that the current contract with Santa Fe Community College is with my separate LLC. I retired from the Cuddy McCarthy law firm January 1st, 2016. So I've been retired from that firm for 3 years. I am what's called of counsel with the firm. So I still do some limited work with that firm, but not anything having to do with this college. All the work I'm currently doing for you is through my separate LLC.
Questions?
And your contract at the outset was promulgated by the Board of Trustees, and you signed a document which indicated the terms and conditions and dates and all that.
Correct.
For the purposes of advising this council or this board. Is that correct?
Yes. Yeah, I was contacted 2 years ago, just as this board was getting going, as collective bargaining was getting organized, and asked if I would be interested in handling your representation, and I said yes. And so I was sent a contract and signed it, and that's all I thought about at that point. I didn't really think much about how that was done other than that I'd been requested to do it. It's not unusual for lawyers to be hired to represent a client that has somebody else actually responsible for the fees or the costs.
Do you recall at that request, was that at the request of the board itself or representing the college? Was it the administration or was it council? Or how, do you have any recollection of it?
I think the initial call came from the college's council to see whether or not I was available and interested, and it processed from that point on.
Any other questions?
Were you aware of any kind of bid process, or it was just you were sent a contract and asked to sign it?
I think it was handled as a small purchase, and it still is well within the, dollar limits in the procurement code for small purchases.
Okay.
Thank you very much.
Thank you kindly.
Thank you.
Okay, at this point, can I hear a motion to go into closed session so that this board can deliberate on our decision following the information that's been presented to us this morning?
I move that we go into closed session.
Second the motion.
And all in favor?
Aye.
Aye.
Aye. So we will move into closed session. I believe that we will go into a different location. Is that right? So everybody else can hang around here, and we will return as soon as we have a decision to share. Okay, I would like to end executive session. The matters in closed session were limited to that specified in our motion to enter into executive session. Can I have a motion to end our executive session?
I'll move to end.
Second.
And all in favor?
Aye.
Thank you. And can I have a motion to act on our deliberations?
Yeah, I will move, make a motion to deny the union's request to remove Mr. Kennedy as counsel to the board.
All in favor?
Give a second.
Oh, I'm sorry.
Second.
All in favor?
Aye.
Aye. We have made and approved a motion to deny the union's request to remove Mr. Kennedy as counsel for this board. And do we have any comments on that motion?
Madam Chair, I wanted to make some comments directed to the parties with regard to our decision. We appreciate the helpful briefing and the oral presentations provided today, as well as the thoughtful responses to our questions. We're also grateful to Mr. Kennedy for his willingness to respond to our questions as well. While we've voted to deny the request to remove Mr. Kennedy as counsel to the board, based on the arguments and the record before us, we do think that the issues raised in these proceedings are important, and we respect the concerns that were raised by everyone. To prevent any potential for harm or bias or appearance of bias to any of the parties in the two PPCs that are currently scheduled to be heard in early March, we're going to put the following steps in place. Mr. Kennedy will resume responsibilities as counsel to the board, which will include advising on all procedural and scheduling matters and all functions as counsel to the board, with an exception. And that exception is that we direct counsel Amy Yeager to serve as counsel for the closed sessions relating to the PPC proceedings in March, and Mr. Kennedy will not participate in any way in those closed sessions.
Thank you all. Thank you, Member Kaufman, Member Gonzalez, Ms. Yeager, Mr. Kennedy. Would you resume your place at our table? And I would just like to confirm our that we're taking these steps out of respect for the concerns that have been expressed. And we hope that the steps that we're taking are received in that way. Okay, so let's move on with our agenda. Next item, do we have any public comments today?
No, we don't.
Okay. Item 8, an update regarding collective bargaining negotiations. I expect that might be a rather brief interlude, but would you like to take your place at the table? Or
I can
speak from the...
I'll just speak.
Okay.
I think from the college's point of view, as we discussed in the last couple of sessions, we provided a last best offer and believe, again, that we are in the impasse procedures that are outlined in the resolution. So that's it.
Yeah, and we are still in the same position where we don't believe that we're at impasse and we wish to continue negotiating.
Okay.
And the PPCs kind of stand for them.
Okay. So we will have a lot to talk about in our hearing in March. Next item, 9A, discussion and possible action to address and clarify relationship between Santa Fe Community College and the Labor Management Relations Board. And some issues have come to light that we are taking seriously. Colleagues, would you like to share your thoughts on any of these issues?
Thoughts. I was not on this board when this whole process started, so I can come at this in a little different perspective. Our process is very essential in how we do business, how things are done. And it concerns me that on the role relationships between this board and the governing board in terms of statutory compliance and what we have authority and don't have authority to do. And I think in looking down the road with respect to council, in order to avoid issues, that it's probably appropriate in our interest as an independent board to engage and look at a process, perhaps through an RFP or some approach to designate the appointment of legal counsel under the appropriateness clause of the statute, which is the governing body. And I think we can work through that. I think there's ways to do that. I think the relationship is very important. We don't want to get into issues of contention on who does or who does not have the authority and power to do that. I think the statute is pretty clear there. But we need to be a part of that process on the front end. And so I think going down the road that we should indicate to the governing board that it would be appropriate to enter into some process for the selection of counsel in the future. I don't have date certain on that or anything that we would determine today, so that you can avoid issues that has come up in this reason for being in this room today. And I've been through this before. I've seen this work through it. I think you need reasonable people to get at that so that we're doing the right thing for the good of the college, irrespective of decisions that are taken by the union or management. I think we're not into that. We're thinking what is the best way to get at this to avoid issues of concern that might come up in the future. I think that the issue here for me is, as a board, you want to do the right thing. You want to have issues that you want to have the role relationships such that you can do your work and avoid these extraneous types of issues that pop up during the. By the way, this is not what took place, in my view, outsider looking at this and the way that this process took place in the front end is not unusual. I think the college was totally appropriate in wanting to initiate and get moving on this board and all that is necessary for the kinds of things that are appropriate for our use. That's not unusual. It happens in many community colleges, with foundation boards, with other boards of concern. And in my experience in collective bargaining, this is not an unusual thing. But in order to avoid the situation that has occurred at this college, I think there's a way to do that. Get back in alignment to have counsel at our side that we need to have as we move down the road. That's a thought.
Thank you for your comments. Any additional comments?
Yeah, I would echo what you said, Tom, and I think it's important to stress that I think collectively the board, and I think it's unanimous among the parties, the way in which council was chosen for the board when this board wasn't even really in existence yet was compliant with New Mexico law and was the right thing to be done. But I think now that we've been aboard for some time, I guess I should add that Mr. Kennedy's role in that was essential because this entire process has been procedural. He's helped guide the board through a number of issues, and we appreciate that. Now that we've gotten to this point where we are a board and we are making decisions and we do have a number of really substantive things coming up, I think as a board, it's important that we at least find some way to communicate to the governing board that it's probably time to, as Tom said, either rebid the legal contract or find some other way to go through that process again, and to make sure that it also complies with New Mexico law and that we have some input in that process. And I think that will hopefully allow transparency and allow all the parties to feel like this is a fair and open process, as open as it's been thus far, to try to continue that.
So can we then request that perhaps Ms. Yeager construct a memo of understanding and share that with the governing council? Would that be an appropriate step?
It's fine. Yeah.
Okay.
I think so, yeah.
Okay.
Yeah.
And timing for that would be as soon as possible. Okay.
Madam Chair, may I speak please on behalf of the SFCC? I appreciate everyone's comments and understand where everyone's coming from, and appreciate the decision-making process that you all went through today. I think it was very comprehensive and appreciate that. I do have a concern under the Act and the resolution about how we continue with Ms. Yeager. We have a position that you all would like her to continue in for these PPCs and payment for her and those contracts, which will need to be discussed with the governing board for that process. So I will take that back to Ms. Mosteller, who will take it to the board, and then we will need to figure out the steps and the process to do that and what their decision is regarding that, because of the issues that were presented to you today in terms of the law and the resolution for the payment of those fees and their role in those decisions as well.
So could you share with us what the timing will be for, because that it will definitely impact how we proceed. So
Agreed, Madam Chair, and I need to speak with my law partner, Ms. Mosteller, who communicates more directly with the governing board in her position, and we will report back. To whom should I report? To Amy or to John or to
John and Marlene.
and Lynn will be able to provide a time frame of when they, I don't know when their next meeting is scheduled. I don't know what the timing is going to look like, but I do understand that that could impact the scheduling we did today. But it is an issue that we're going to need to address. So I just wanted to bring that to your attention before we left today. Thank you.
a question for you. Amy's services have already been approved by the governing council, so what kinds of concerns might
My understanding is that, excuse me.
Please, yeah.
My understanding is that her services, and I could be wrong, so if my understanding is incorrect, someone correct me, but my understanding is her services have been approved through the decision today, for purposes of getting through the decision you all just made on the council issue alone. I don't believe that her services have been approved outside of the decision-making process today. So that's the additional step I think that we need to get clarification.
Okay, I understand.
And Madam Chair, I'll just check that and get that information to you too.
Okay, appreciate that. Thank you.
Thank you.
And hopefully we'll be able to ride this wave and not have any delays on that regard. But thank you for bringing that to our attention. Okay, next discussion item 9B, discussion and annual adoption of Open Meetings Act resolution. We're required, Mr. Kennedy, to review this and renew it annually.
Certainly, under the Open Meetings Law, you're required to adopt an annual resolution providing the public notice of the types of procedural steps you will follow to comply with the Open Meetings Law. So I would recommend you re-up it.
Okay.
And doing it at one of your early meetings in the calendar is usually the way it's done.
Mm-hmm. Members, have we had an opportunity, or have you had sufficient opportunity to review our open meetings resolution, and do you recommend any changes?
I don't recommend any changes, but sure.
No changes for me. So do we need a motion to adopt? Is that how we would?
Yeah, I would just comment that I think we need to reflect on the concern that was expressed before our January 18th meeting regarding notification procedures. And I would ask Mr. Muir, do you have any ongoing concern, or are you comfortable that appropriate procedures were?
Madam Chair, it was, just to clarify, the concern that was raised was a couple of days before this last meeting was scheduled. We were trying to confirm the time that we were going to be presenting before the board, and went to the website, on the college's website, and the meeting was published there. So we went to the Open Meetings Act resolution, which all passed, and looked through the language there, and it states that within 10 days it will be posted in the newspaper of local circulation, and on the college's website, and in places around the college. When it wasn't posted on the college's website, the concern was that Open Meetings Act challenges can be brought by anybody within the public, and so we just raised that concern that if we go through all of this expense and everybody shows up, then we have to redo it. And so we don't have any further concerns as long as our interpretation of that and is correct. That 10 days applies to that whole sentence, and we think it does grammatically. That's why we raised the board's attention. So
Okay.
I think going forward, we just wanted to make sure that was clear.
I think we need to clarify that. My understanding is that and commas are funny little things, right? My understanding is that the notification has been consistent, not only with this board, but with other boards that are under the aegis of the community college, and that nothing different was done in that meeting than for any previous meeting. So we rely.
Let me clarify one point.
Mhm.
Thank you. Madam Chair. I'm sorry to interrupt again. But what I guess my point is that nothing was done improperly in the meeting. It was properly noticed at the meeting. The sentence in both sections 5 and 6 of the Open Meetings Act resolution required that it's not only posted in the newspaper but on the college's website, and it was not posted within that 10 days.
The question is
Yes.
within the 10 days, right?
Within the 10 days.
My
So it was not there on the website.
I would have a different interpretation of that.
Well,
So I think we need to clarify interpretation.
Thank you.
Okay. Members, would you like to have a discussion about commas?
No.
My understanding is that the notification requirement specifically references newspapers, and that I don't interpret that comma as requiring that the agenda be posted on the website within that 10-day period, but that the agenda be posted on the website, period.
At some point before the meeting,
Correct.
and not 10 days.
And I think that an expectation that a final agenda be posted on the website 10 days before the meeting is, an agenda is going to change in those last 10 days.
Right.
And so, I think that we could run up some other concerns.
One further point.
Mhm.
It's not the agenda being posted, it's the meeting time and place that was not posted. And whether or not the clarifications are here, I think the concern is, the larger concern is if we're all here, we understand that. But a member of the public, who is the Open Meetings Act resolution is required to address, it reads that, they may have a different interpretation, regardless of what's noted here. That's the concern. And it wasn't that the agenda be posted, because there's only 72-hour requirement.
Yes, thank you for clarifying.
Yes, thank you.
That's section 5.
Section 5.
Mhm.
So I guess the question I have is whether we did anything differently in the January meeting in terms of posting notice of the meeting, time and place than we normally do, are we capable of getting it up in the newspapers and on the website 10 days in advance? Or should we remove the website requirement?
Yeah, the comma is after meeting. This is what how the language reads. Let me read section 5. Okay. For the purpose of regular meetings described in paragraph 2 of this resolution, reasonable notice to the public of all regular meetings of the SFCC Labor Management Relations Board is determined to be and shall be by publication of the time and place of the meeting in at least one newspaper of general circulation within the district at least 10 days prior to such meeting, comma, by posting such notice on the Santa Fe Community College website and in a prominent location in the administration area of the Santa Fe Community College, and by announcing at each regular meeting, comma. So to me, the fact that there are no commas, that the comma is before by posting such notice on the Santa Fe Community College website, to me, that separates that requirement from the 10-day notice requirement. I think that the reference and are there any English majors here? But just a regular reading of this language to me separates that the 10-day requirement, specifies that refers to at least one newspaper of general circulation within the district. That's my reading of that language.
Well, I think we should clarify it, because I think there is clearly another way to read it. And
that has been the practice.
Right.
That has been the practice.
We want to avoid the challenges. Right. I think everyone agrees, but we want to avoid the challenge. So maybe so my question is, and I'm not exactly sure who to direct this to, the question is, are we capable of noticing the time and place of the meeting 10 days before the meeting in the newspaper and on the website? Or should we remove the website requirement? Because we're going to put the agenda on the website anyway, 72 hours before. Should we remove the website requirement 10 days before so that there's no potential Open Meetings Act violation in the notice?
What's been the practice in the past? Has it been the
10 days in the
10
newspaper?
days in the newspaper?
Right.
If I may, again, and on the website. That's why this became an issue, because it has been posted in the newspaper and on the website 10 days ahead of time in the past. That's why this became.
Can I answer that?
Yeah.
Because I'm the one that's, it's been posted in the newspaper 10 days prior. The posting on the website is the agenda on the website, and that is 72 hours before the meeting. It's not ever been a situation where it was the agenda or the notice of the meeting was 10 days like it is illegal.
So then that's,
Yeah.
but that's been the practice.
That's been the practice for the last 5 years that I've done it.
For this board as well as for other
For this board
boards.
as well as the
And
government.
you've had no complications.
And there've been no,
Right, or challenges.
exactly.
Thank you for that clarification.
Yes.
Special guest star appearance today.
So I think what we need to do is we need to change that comma to a period. And we need to remove the reference to the website and in a prominent location at the college. Take that entire remaining clause out and then talk about the published notice of the regular meeting shall contain a statement that the agenda will be available on the website 72 hours before. So it's paragraph 5 and paragraph 6. We need to make some language changes and then probably adopt this maybe at the next meeting.
Okay. Can we, since this is a discussion item and not an action item?
So we'll get a redraft.
It's on your agenda as an action item.
No, it's a discussion and annual adoption of.
I would suggest we get a redraft and take it up at the next meeting.
Okay.
Fine.
Okay, let's do that. Okay, any other items for discussion? Do we have a motion to adjourn?
So move.
Oh, please.
Can I just clarify, Madam Chairman, just real quick, when we scheduled for March 4th and 6th, you scheduled for both PPC?
Yes, both PPCs and the challenge.
Okay. And will we take them in a certain order?
How about 2-3 challenge? Or a counterclaim?
So in fact, the way we presented this morning is that, right? So who brought the PPCs first?
No,
Right.
I'm saying.
Oh, are we going to do PPC 1 and then PPC 2 and then?
Versus
Okay.
two, yeah. Like, I would do that.
Yes.
PPC first and then the
Do you have any recommendation,
I think-
Mr. Kennedy?
Why don't I get both of you on the phone and see how we
so
can do
we'll
it
just organize
efficiently?
that through the schedule.
Is that fair?
Yes.
And John, for that one, you don't need me, you can just coordinate with him.
Okay.
And he can tell me what to do.
And I think that it would be in everybody's interest if we can complete the process in one day. That would be great. We schedule 2 days in the event that that time is needed, right? Any other business? Questions, comments? I would like to share that I believe that this was a very healthy process. And I thank everybody, and particularly board members and council, for everyone's participation in this process. If we're about transparency and integrity and respect, then I think we demonstrated that in how we proceeded today. So thank you all. So do we have a motion to adjourn?
I'll move to it.
Second.
And all in favor?
Aye.
We are adjourned. Thank you.